On TVW, the Washington State Supreme Court hears oral arguments involving wrongful termination. This case was heard in Olympia on May 15th.
The Supreme Court is reconvened.
You may be seated. Our second case this morning is Diane E. Sedlacek, respondent, versus Larry O. Hillis, et al. Petitioners. Mr. Hickman, you have reserved 20 minutes for opening. Mr. Stock and Mr. Needle, you're dividing 1/2 hour, 15 minutes apiece, and Mr. Hickman, you then have 10 minutes for rebuttal. You may proceed.
Thank you, Your Honor. May it please the Court, I'm William R. Hickman. I represent Mr. and Mrs. Hillis. They are the petitioners. They are the employers. The facts operative to the appeal at this stage are very limited. The Hillises are general partners in a partnership which owns an apartment house, 194 units in there. They have 2 employees, the Sedlaceks. In an apartment house, it is important to maintain a low vacancy rate. The number that was considered problem was 10. The Sedlaceks were hired in 1988. In 1994, the vacancy rate had risen to around 15 per month. This created some problems. In December of 1995, Mr. Sedlacek was diagnosed with leukemia. In February of 96, the vacancy rate was now up to 37. The Hillises hired a property manager to come in, reviewed the situation, identified some problems. The Hillises hired the property manager to come in and be on site for a month and see about eliminating the problems. The vacancy rate went down. The Hillises asked the property manager to take over management of the facility. The property manager agreed on the condition that the Sedlaceks be let go. The Sedlaceks were let go in March of 96. In July of 96, Mr. Sedlacek passed away. In the summer of 96, the Sedlaceks sued the Hillises. First, for 4960, disability discrimination. Second, common law wrongful discharge. Third, negligent infliction of emotional distress. And fourth, the tort of outrage. After 2 summary judgments, all the causes were dismissed. Mrs. Sedlacek appealed. Judge Kennedy of Division I wrote an opinion affirming most of the dismissals. In particular, the RCW 4960, the law against discrimination claims, were all dismissed because that law applies only to employers who have 8 or more employees. Mr. and Mrs. Hillis had 2. But what Judge Kennedy then did was extraordinary, and the reason that we're here. Judge Kennedy said that the legislatively created small employer exemption did not apply to the common law disability discrimination claim of Mr. Sedlacek. And then she said that Mrs. Sedlacek, who was an able-bodied individual, could also sue for common law disability discrimination.
Are you disputing the Court of Appeals determination that, in fact, Jack's claim is viable as a under common law tort?
To the extent that the second point that Judge Kennedy did, extending the class, to the extent that she piggybacked on top of finding that he had a claim, I think his claim is suspect, because one went on top of the other, and we can't look. We have to look first at his, then we go to hers. And in looking at his, I think the court should look very closely because of what Judge Kennedy did there.
But it appears from your pleadings that you did not assign error to...
We were the respondent. Our position has been they have no claims.
But here...
Our petition for review was based on the extension to Mrs. Sedlacek, yes. Now, in order to analyze it, you have to look at what the court did for Mr. Sedlacek. And in looking at that, you may have to look very carefully at what was done there.
But in order to appeal to this court, you have to put us on notice of what it is that you are appealing, and it appears to me that you're not appealing that determination. This is a follow-up to Justice Bridges' question.
Our petition for review set out that the issue of substantial public importance was the extension. Yes, Your Honor.
Thank you.
So it is the derivative claim, the associational right, et cetera. That is what you are challenging.
That is the primary challenge, yes. And in order to challenge it, in order to look at it, to analyze it, we analyze the claim that it is based on. Because then it becomes the novelty of what Judge Kennedy did becomes even more apparent when we look first at the other claim. Because what Judge Kennedy said, her reasoning was, we take the public policy expressed by the legislature in the statute, which statute says by its terms that the legislature is made expressly unavailable to this claimant. And then she said, however, this claimant shall have the benefit of that public policy which the legislature has said is not available to that claimant. And that's just part of the problem. First of all, we're talking about in terms of the tort of wrongful discharge. And the first thing when we look at the cases, the first thing we learn about it is narrow. It is to be very narrow. What Judge Kennedy has done has taken the tort of wrongful discharge and, following her opinion, it will now apply to age discrimination, marital status discrimination, race discrimination, creed, color, national origin, mental, physical disability. 7 new categories added to a tort that is supposed to be narrow.
Well, counsel, it wasn't Judge Kennedy who made that happen, is it? It wasn't at this court? Roberts versus Dudley?
Yes, indeed.
Well,
yes,
what can I do about
indeed.
that?
This court, in a sex discrimination case. Now, in that sex discrimination case, there was I'll get into that in a moment, but I want to answer your question. There's a major difference between a sex discrimination case and a disability discrimination case. And that is that we have a public policy in the Constitution, the Equal Rights Amendment. And that makes a difference in my mind, a huge difference.
Well, it didn't make a difference to the majority. That argument, that particular argument, was raised in the concurrence in Dudley, was it not?
In the concurrence, and Justice Alexander raised it, and Justice Talmadge raised it, and it is extremely important. The author of the opinion said it wasn't important. I think what the Constitution says is very important. I just watched Mr. Charlie Wiggins argue about...
In Thompson, we used a federal statute as being the ideology, if you will, of public policy.
No, Your Honor, that was not public policy. What was done in Thompson was say there's a federal statute, and if you violate a federal statute, that's a crime. Violating a crime is against public policy. That is what was done there. That is where the federal statute got injected. It was a crime. It is a given that to violate a crime is to commit a crime, is to operate against public policy. That is what that said. We have now shifted over here, and this is what I wanted to come into about where did this tort come from? Where did this common law tort come from? In Gardner, the court pointed out there were 4 reasons that this common law tort had developed. First of all, firing for refusal to commit an illegal act. That's not this case. Firing for performing a public duty. That's not this case. Firing someone for exercising a legal right. That's not this case. Firing in retaliation for reporting employer misconduct. Thompson was 1 and 4. That's not this case.
Where is Dudley? Where's Roberts v. Dudley in those 4?
It's not there.
So you want us to
It's a little hard to put it in there.
Should we overrule Roberts v. Dudley?
I think Roberts can be upheld on the basis of the Equal Rights Amendment to our Constitution as setting forth a public duty, a public right, public policy in our Constitution.
But
that is what saves the excuse me, Your Honor.
Absent a constitutional provision, I guess it would be your view then that if the legislature establishes by legislation a right or a public policy, but does not provide a legislative remedy to vindicate that public policy, that it would be inappropriate for the judiciary to entertain such a remedy?
I have two answers to that. One, it involves the problem of the separation of the powers. But the more specific answer is the legislature defined public policy in this instance, and it said the public policy here, discrimination, Washington statute against discrimination, applies to employers with 8 or more employees. That is the public policy. You can't take one half of the statute and say this public policy applies to everyone, when the legislature has said this public policy applies in instances where the employer has more than 8 employees. It is like taking an insurance policy and reading the insuring agreement and saying, well, the CGL policy says you agree to pay on behalf of the insured, all sums the insured becomes legally obligated to pay, period. And not looking at the exclusion in the CGL policy that says this doesn't apply to automobile accidents.
Well, back to separation of powers, though. I mean, does not the judiciary have the authority to develop a common law?
Absolutely.
Establish common law rights of action?
And that's what,
irrespective of what
that
the legislature does.
has been going on with this common law tort.
Precisely.
And this, my view is to take a very careful look at it. The first thing was to look at it, and this court has said it's been very narrow. The second thing to look at is what are the cases that have given rise to it. It has been these type of cases, these 4 categories, where it jumps off the page at you. An employee is fired for going to take part in jury duty. An employee is fired for putting in a workers' comp claim. Those jump off the page at you. That's clear. So those 2 things. The third thing that the cases tell us is the claimant must prove the existence of a clear public policy, not an ambiguous public policy or a public policy that might be there somewhere or we can try to find. It's supposed to be clear. And we're supposed to look to the Constitution, and we're supposed to look to the Revised Code of Washington, and maybe even look to the WACs to see if this clear statement of public policy is in there somewhere. And we can go all over the Constitution, just as you did with the case ahead of us, and you're not going to find anything in there about disability discrimination. And you look at the Revised Code of Washington, and you will find something about disability discrimination, and it says, disability discrimination is against public policy for employers who have 8 or more employees.
Well, counsel, I'm having a little problem here. You, in response to Justice Ireland, said that you were not challenging Mr. Sedlacek's cause of action.
That's right. I haven't gotten to Mrs. Sedlacek's yet.
No, I know. It sounds to me like, from everything you're arguing here, you don't think he has a cause of action either.
I don't think he does. No, that's absolutely right. But let's look at it, because hers is piggybacked on his. As mentioned in the legislation.
In this case, don't we have to say he does have a cause of action because you didn't challenge it, and that's the way that this cookie crumbles? I mean, he has a cause of action. Don't we have to start with that premise?
I think you have to look at your cases continually. It is distinguishable. Roberts is distinguishable, as I mentioned. But we're here still trying to get to Mrs. Sedlacek. And what I'm giving you now are still the basis of this common law tort. And it doesn't, and as we go through this, the court may become aware that it doesn't apply to Mr. Sedlacek any more than it doesn't apply to Mrs. Sedlacek, but we're here because there was an expansion of a questionable doctrine in the case. The final point, the final 4, there are 4 points in this, is in Thompson. The court said in Thompson, we should proceed cautiously in this area. So that's the analysis of this tort. It's narrow. The conduct, as we've seen here, isn't in the precursors to this tort. It isn't in the statute, and to proceed cautiously with it. But all of that in mind, Judge Kennedy then said, we hold Washington common law recognizes a cause of action for unlawful discharge in violation of public policy based on disability discrimination. And that statement doesn't hold up to analysis. But then she went on, and then she said something even worse. She said that Mrs. Sedlacek, an able-bodied individual, was also entitled to disability discrimination claims. She said, "We deem it irrelevant that Mrs. Sedlacek was not herself disabled." Irrelevant. What would be more fundamental to a claim of disability discrimination than being disabled? And more important, there's not a single case cited. There's not a constitutional provision cited. There's not a statute cited. There is not a
Doesn't she claim it's based on some kind of a freedom of association because they were hired as partners?
A team, she called it. A team is not a legal entity that I've ever been aware of. We deal with people as individuals.
Well, what about the drawing in, she goes further than that, does she not? I mean, she's drawing in public policy of the federal law, which does, in fact, provide that a person who is not disabled.
No, there's
is
nothing in
associated-
her opinion about federal law,
No,
I don't
not-
believe. There's only 2 paragraphs on this
Not
whole
just-
analysis.
excuse me, if you'll let me finish the question, then you can give me an answer, I'm sure. Judge Kennedy does not do this, but certainly it's argued by your opponent that that is a basis for the public policy of including Diane Sedlacek, yes?
They are making that argument. I find
wrong
it
with that?
excuse me?
What's wrong with that?
It's incongruous. It is incongruous. The other, Washington, D.C. They are arguing that a legislative body enacted a positive statute that we should interpret as reflecting the public policy of the state of Washington when our legislative body did not enact it. Yesterday we saw or heard in this morning's paper pointed up a little difference in opinion as to public policy as to the medicinal use of marijuana. The people of the state of Washington made it very clear what the public policy is in the state of Washington. The feds have a different idea. I don't think it would be safe to assume that a federal point of view, a federal public policy can be adopted or imported without criticism, without checking, without looking at it. I don't think it's an automatic by any stretch of the imagination.
Doesn't that really go to the, again, the narrowness
We're back to narrow.
of the definition of how this tort should be?
Not only that, the feds, in their statute, limit it to employers of 15 or more. So there's no claim, even
But
under a federal
if
statute.
you could somehow defend a freedom of association claim, which I understood to be the premise that Judge Kennedy was utilizing, that wouldn't be dependent upon Congress's action. That would be based on a constitutional provision. Any comment about that freedom of association analysis?
To create a tort?
Well, to supply as I understood it, her claim of freedom of association was, well, maybe I'll leave that question for the...
I think that's a good point for me, too, because right now I'm going to stop talking and reserve the rest of my time, because I am interested to hear counsel tell us what constitutional provision, what statute, what whack reg supports this expansion of what is supposed to be a very narrow tort. Thank you.
Thank you, Mr. Hickman. Mr. Stocks?
Thank you. Good morning. May it please this court, I am John Stocks. I am the attorney for Jack and Diane Sedlacek, the plaintiffs. Before we get caught up in some of the legal issues, the facts of this case cannot and should not be ignored when deciding whether termination of Diane Sedlacek was wrongful. This is a case about cancer. Jack acquired cancer. He was a longtime employee, and when his cancer came up and the employer knew about it, which is undisputed on the record, all of a sudden he was terminated, he was shunned, and so was his wife, and they were kicked out of their apartment, which was one of their employment benefits. They were not only thrown out of their home, which was an employment benefit, but they were without health insurance, which was an employment benefit as well. Their termination was wrongful and against public policy. It's important, as Justice Bridge pointed out, that they did not appeal Jack Sedlacek's claim. He was disabled. There's a reasonable inference that he was terminated because of this disability, and therefore he has a valid claim, and that is not before this court. It is the law of this case.
But Diane Sedlacek was not disabled, was she?
Correct. She was not disabled.
So she wasn't terminated for a disability that she had, correct?
Well, one could argue that she was because she was under the...
You just said she wasn't disabled.
She wasn't disabled, but she could have been terminated because of disability discrimination, not because of her own disability.
My question was, she wasn't terminated for a disability that she had.
Well, technically, she had the disability of being associated with a disabled person.
Well, that's not
Which-
a disability under either federal or state law.
It's not technically a disability, but it can lead to disability discrimination of a person who is not themselves disabled physically or mentally.
Well, I think it's important that we try to use some precision with regard to these terms.
I agree. Diane Sedlacek was not disabled, but she could have been discriminated against based on a disability.
So that a person who is, say, caring for a disabled relative and is leaving the office early at night, earlier than the person should leave to go home and care for the person and is discharged, that's a disability. They're being discharged because of a disability, is that right?
Because of their association with a person who is disabled.
Counsel, where's that in Washington, either common law or statute?
It's not. The associational claim is from the Americans with Disabilities Act.
Would you say that our common law and statute is at least inconsistent with that, if not in conflict?
It's not inconsistent and it's not in conflict. And
So tell me why, when our statute as well as our case law refers to the person who is disabled.
And your question is, why would we look to the federal law?
Yes.
Well, on July 26, 1990, almost 11 years ago, our Congress stated that in passing the Americans with Disability Act, the following, and this is the number one purpose stated by our Congress. Quote, "It is the purpose of this chapter to provide a clear and comprehensive national mandate for the elimination of discrimination against individuals with disabilities." End quote. This purpose of Congress certainly didn't exempt Washington citizens from the studies that they did and the findings and purposes that they made.
So you're arguing supremacy? And that they're attempting to occupy the field? Preemption?
No,
What?
I'm not arguing, no, because we're not applying the Americans with Disability Act to a common law claim. What this court's obligation is to find a public policy,
Well-
not to necessarily
Counsel,
enforce the statute.
You didn't bring an ADA claim, did you? You didn't bring an Americans with Disability Act claim in your case, did you?
No, because if you look at the second amended complaint, which was
Why didn't
stipulated
you?
to, there is an association claim brought, but I think that's moot, because we're not here deciding whether there was an ADA claim or whether there were 15 or more employees. What we're looking at is a wrongful discharge claim and whether there's a public policy.
You didn't because you couldn't, because there's a 15-employee limit under ADA.
That's the technical reason that she couldn't bring a claim. But if you look at the complaint and you apply notice pleading, there is an association claim mentioned in the complaint, and not only on summary judgment for the trial court, but before the Court of Appeals, the Americans with Disability Act was argued as a public policy. That supports not the ADA claim, but the common law claim.
Well, that brings me to the question I was trying to direct before, which is this association claim based on the public policy announced in the ADA or based on freedom of association?
Well, it's not necessarily freedom of association, it's
So it's not a
association with a
constitutional-
disabled person.
It's not a constitutional freedom of association claim,
No.
correct? Thank you.
It's association with a disabled person under the ADA.
Counsel, is it your
Yes.
view that had the Hillises employed 15 or more persons, that they would have been able to bring an ADA claim?
Yes, in fact, if we were able to prove on summary judgment that there were 20 employees or anything more than 15, there was an association claim in the complaint, and that would have been addressed on summary judgment. And in fact, we anticipated a removal attempt by the defendants because of that association claim. And it's important to look at that from the standpoint that there was an original complaint which didn't have the word association. There was a first amended complaint, the second complaint, which defendants stipulated to, that added this new claim of association. And then it was argued on summary judgment as that's the policy, one of the public policies that should be looked at when deciding if there's a wrongful termination case.
Would removal have been proper? had the,
We would
been
have
able to?
I think so, if it implicated a federal statute, the Americans with Disabilities Act, but that we never crossed that line because we were first dealing with 8 employees. And if we didn't get past 8 employees, we could never get past 15, and that's what happened. The trial court found they employ 2.
The strongest argument that I think your opposing counsel has is the fact that Washington did not adopt this associational protection in its own ADA or its own version of the ADA. How does it then become the public policy of the state if the state made a decision affirmatively not to incorporate that protection, if you will, for Washington citizens?
Well, the key words in your question that I would like to focus on are affirmative decision. The way counsel and in their briefing for defendants argues this is that the legislature somehow contemplated an association claim and rejected it and put in its findings or its legislative findings or purpose, we do not find that this state needs to enforce that policy. That didn't happen. There was no affirmative contemplation of this association claim. Remember
Well, did the association language in the ADA come after Washington had adopted its own version of this protection, this federal ADA protection?
Well, yeah, of course. The Washington law against discrimination, including disability discrimination, came well before 1990 when Congress passed the American with Disabilities Act. And so counsel would like to, and when Justice Bridge asked the question about aren't we inconsistent with federal policy? No. As long as the federal policy, the public policy of the ADA, is not inconsistent with Washington law, and there's nothing in Washington that counsel can point to that is inconsistent with that claim. It just doesn't mention it. And that can't be translated to, well, our legislature intentionally omitted that claim and made some finding as to why they did so. That can't be done.
Is there any precedent for saying that after adopted federal law becomes a part of our own statutory scheme?
No, I don't think this court would need to say the federal law is now our law, but this court would need to say, in order to affirm the Court of Appeals, that we can look to the public policy of the Americans with Disability Act. And as Justice Alexander stated in the concurring opinion of Roberts, you're not being called upon to enforce the ADA or enforce the elements of the torts that are contained therein, but you are allowed to look at the public policy and contained within the ADA in deciding whether this state has that public policy. And when Congress...
But counsel, given notions of separation of powers and judicial restraint, the idea that the source of public policy initially and primarily should be with the legislature, how can Thompson, Gardner, even Roberts be read so broadly to say that this court can find, if we can find a public policy anywhere that provides a certain right, that then we're going to pull it into our own jurisprudence and create a common law tort that protects it?
Well, I don't think you can look at any public policy.
Well, what's the limitation then?
Well, public policies that would apply to our state. If Oregon passes a specific statute as a public policy and it's not in a federal statute or in any Washington statute, that might apply to our citizens
So
of
the
our
limitation
state.
is it's got to be feds or it's got to be the state of Washington?
Well, it could be international law that applies in the state of Washington, but that doesn't really apply to this case. There's no issue there. But I wouldn't limit it to just Washington law and federal law. There could be international law that applies in this state.
Is there any case that has used federal law to find public policy absent a constitutional provision? You're urging that we use the ADA as a statement of public policy.
As one of the places you can look for public policy. You can also look at the Washington statute on disability discrimination under saying that Jack and Diane were a team. But I don't know of a case that has applied what you're asking.
I don't know of any Washington case with the clarification that was made about Thompson, which was a violation of the law, not just following federal law, that has used federal law that's not constitutional in nature as a premise for an importation of public policy. And you don't know of any either.
Well, the Gardner case used the Fourth Amendment of the United States Constitution.
That's the Constitution, not a congressional law.
Right. But the other side of that is this court would have to ignore Congress's the findings of Congress on our nation's policies and the national mandate to get rid of discrimination in the employment context.
So you say if we don't adopt if we don't extend this tort to the person associated with the disabled person, we are violating the federal law?
Not violating the federal law, but the policy and purposes mandated by Congress, which is a national mandate.
Do you think your cause of action could be heard in federal court?
No, because there isn't a federal statute or regulation that would be interpreted or enforced. Federal courts are to enforce federal laws. This would be a Washington state common law. I guess if we stipulated to the jurisdiction of federal court, it could be, but we wouldn't be doing that. So I don't think it can be.
Is there any Washington regulation or WAC or any other provision, whether it be statutory or otherwise, that you could point to that would indicate to this court that this associational concern was a concern of our state legislature?
No. There's nothing I could find that raised that issue, either rejecting it or accepting it or contemplating it.
What about the concepts that this is to be, that the entire doctrine of wrongful discharge is to be narrowly construed, that the conduct is not within the parameters that are generally set out for a wrongful discharge case, and that we should proceed with caution under Thompson? I mean, don't those argue against blanket extensions of the kind that Judge Kennedy has made here?
Well, those sort of principles would also argue against Roberts versus Dudley, which didn't apply the common four situations of wrongful discharge. But because it's a narrow exception, doesn't mean it's a non-existent exception.
But at least in Roberts, where the only issue that was really raised was the clarity element, which does require the existence of a clear public policy. You just said that there's no Washington statute, there's no Washington regulation that would provide this associational protection. How is that clear public policy?
We have a national mandate. The wording of Thompson is a clear mandate, or contravention of a clear mandate of public policy. We have the Congress saying, here's a national mandate, and they use the words, we want to make it clear and comprehensive that this is our policy. But to back up, we don't need the Americans with Disability Act policy to enforce Diane's claim, because as counsel, and I think we agree on something, her claim is derivative of Jack's claim. If there was discrimination of him on a disability basis, then her claim is derivative of that, and she was terminated because of that disability.
Only if we deem them to be virtually the same person.
Well, they were a team. There was no way that they're a right hand and a left hand.
What's a team at law?
Well, it's the right hand and the left hand. They were hired together. How could Diane continue her work without her husband? If he was disabled and they discriminated against him, she couldn't.
Point of fact, she did continue to work without him, did she not? When he was hospitalized, she continued
For
the
a
job.
temporary period of time, but after hospitalization, he came back and they worked together.
Well, counsel, then if a stock brokerage firm hires a couple of people together and says, you're going to be a team, and one of them gets disabled and they're both discharged, that second person, who is no longer a member of the team now, would have a disability claim as well? I mean, they're not married. They're strangers to each other in the legal sense, but they're a team. Is that going to apply?
I don't think so, because they're not married.
So the marriage is an aspect of this.
That's one of the elements. But I think in your situation, you wouldn't be applying a disability discrimination claim anyway. You'd be applying a policy against disability discrimination. There's a difference there. So the non-disabled team partner who gets fired in your stockbroker analogy wouldn't have a disability discrimination claim, but might have a wrongful discharge claim. Thank you.
Thank you, Mr. Stokes. Mr. Needle?
I thought the marriage was kind of an unstated premise there, too.
Mr. Chief Justice, and may it please the Court, my name is Jeffrey Needle. I appear as amicus curiae on behalf of the Washington Employment Lawyers Association. Defense counsel would argue that as a source of public policy, this Court can rely on only Washington law and exclusively only on Washington law. Quite simply, we think that's wrong. we think this court should be able to rely on any public policy which is enforceable in the state of Washington. As stated by counsel, we do believe that that would include federal law. We believe it would exclude the law of the various different sister states because their public policy is not enforceable in this state. For example, we think it might include ethics codes. So if there was a doctor and the doctor refused to violate the Hippocratic Oath and he was terminated from employment he or she was terminated from employment as a consequence, we think that would be enforceable because it's a public policy enforceable in the state of Washington. Whether or not international law would apply or not remains to be seen. One can think of hypotheticals where it might. But the touchstone is whether or not the law is enforceable in the state of Washington. In this case, the Court of Appeals didn't manufacture public policy. They didn't manufacture, as claimed by defense counsel, a protected class. The United States Congress did that. Defense counsel asked us to entirely ignore federal law. If we do that...
Could I ask you something? It's just been bothering me, I guess, about the whole side of your case, and that is every law that's passed, at least in the state of Washington, represents public policy, does it not?
Arguably.
Is there any limitation on this tort?
Well, yes, there are, Your Honor. There are elements spelled out on the tort. It's an intentional tort. In order to prevail, you have to make the 4 elements that are spelled out in Gardner versus Loomis and Dicomas and the whole list of cases. You've got to prove that the employer knew about the public policy and that he intentionally fired the employee because of the public policy. And if that happens, and if you make the other elements, Your Honor, indeed, it's a viable cause of action, and the plaintiff can prevail.
But those elements really all go to conduct, right, until we get to Roberts. Roberts is a status situation. So how do those other 3 elements fit into the status situation? How do we apply them?
Well, I think that what you have to do is, for example, in this particular situation, you're talking about the disability, the associational, I think you're talking about, arguably you're talking about 2. You're talking about the Roberts versus Dudley scenario expanded to disability discrimination for Mr. Sedlicek or his estate. And on the other hand, you want to, the question is for Mrs. Sedlicek, you have to...
My question is really more on Mr. Sedlicek, and whither goest the other 3 factors from Gardner?
I think you essentially have to prove a disability discrimination claim. I mean, I think that's the essence of it. I think it's the same elements that would apply for a disability discrimination claim, in essence, would apply for the public policy wrongful discharge claim. I think in order to prove the public policy, a violation of the public policy underlying the RCW 49.60, you have to prove the elements of a violation of RCW 49.60, and I don't think there's a meaningful distinction there. If this court should exclude consideration of federal law as a source of public policy, just think of the list of horribles. A person could refuse to cheat on income taxes and could be fired with impunity. Just think nuclear safety regulations, environmental regulations, including the Clean Water Act, federal income tax laws, food and drug regulations, federal safety transportation statutes. All of these are public policies that are enforceable in the state of Washington. All of these statutes that I've just mentioned have been recognized as a source of public policy in sister states for their public policy torts. I'm not asking this court to do anything it hasn't already done. It's already recognized federal law as a source of public policy in the seminal case of Thompson versus St. Regis. I'm only asking this court at this point to recognize that the ADA is a clear source of public policy which should be enforced. The purpose of the public policy, there are collective interests. That was a point raised by a defense counsel in his answer to our brief. There are collective interests, and the interests are to prevent disabled people from becoming pariahs so that other people can associate with them and do so without risk of termination from employment. That's the underlying public policy issue for the associational discrimination claim. There is a tremendous history in this country of people who just disassociate themselves from disabled people. and disabled people have become pariahs in the past. They historically have become pariahs and outcasts. Is to prevent that circumstances from occurring, the Congress passed the associational prong for the ADA.
Counsel, the fact that it's limited to employers who employ more than 15 persons does not limit the use of that. I certainly know that we did that in Roberts versus Dudley, but that was, of course, state law. We have to get over really two hurdles, don't we? One, the ADA doesn't apply because there are not more than 15 employees in this circumstance. So we're using as a source of public policy a congressional act that doesn't apply in this case.
Well, the Washington state law against discrimination didn't apply in Roberts versus Dudley.
Right, but we would have at least our own state law. I mean, I guess I'm saying that it seems to me you have two hurdles here.
Right. My answer, Your Honor, is Roberts versus Dudley.
Right.
I mean, as I understand defense
counsel in Roberts versus Dudley, the way the majority wrote the opinion was that it said a right has been created and there's no remedy. We're creating the remedy. It wasn't that the public policy is stated in the Washington law against discrimination, because that wouldn't have flown, because that public policy is limited to employers of 8 or more.
I'm not sure that I agree with Your Honor on that. I do believe that for every right...
Let's ask Justice Sanders.
Well, Justice Sanders, I understand he wrote the decision, and perhaps we'll hear from him for a second. But I'm a great believer that for every right there must be a remedy. I understand Marbury versus Madison, and I espouse it heartily, Your Honor. But I don't necessarily believe that that was a philosophical basis for Roberts versus Dudley. I do think that the court was recognized the public policy reflected in the law against Washington discrimination. That law, the public policy reflected in that law, was the touchstone for the court's decision. And it was a public policy tort, sought to enforce that public policy. We're now seeking to enforce the public policy reflected in the ADA. And if the court does not do that, then the court, it seems to me, either has to overrule Roberts versus Dudley, which is the implicit suggestion by defense counsel, although he wouldn't say so, or the court has to reject federal law as a source of public policy, which I think requires you to overrule Thompson versus St. Regis, because you've already gone down that road.
What about his argument that, well, Thompson versus Regis that he made to Judge Bridge in answer to her question about Thompson, that, well, it wasn't really the public policy stated, it's the fact that it was the commission of a crime, and it's the commission of a crime that's violation of public policy?
I don't think there's any basis for that distinction that I can see. I mean, no other state has made a basis for that distinction. It's not a violation of, it's not a crime to violate the Clean Water Act. It's not a crime to violate transportation and safety regulations. If there's a trucking company, Your Honor, and the trucking company is in violation of some federal safety regulation in terms of maintaining the trucks, and the employer says, well, I'm not going to get in that truck and break the law, because I know by doing so, I'm going to imperil the safety of innocent people on the road. And the employer says, well, you know, too bad, you're fired. I suggest that that's a public policy that this state needs to enforce.
Whether it's a crime, whether it's the
Whether it's
commission
a crime or not a crime. And I don't know of any basis, I don't know of any case in all of the other sister states that make that distinction. I think counsel's reaching to make that distinction because he needs to distinguish it in some way, I suppose, but I don't think that's a meaningful distinction. I think the public policy needs to be enforced regardless if it's a crime. If you're working out at Hanford, my goodness, if you're working out at Hanford and you recognize that there's some unbelievable safety problem associated with the way the tanks are being stored, and you bring that to the attention of the various different authorities and you wind up getting fired for it, the safety violation in and of itself wouldn't necessarily be a crime. But don't we want to enforce that public policy? Don't we want to encourage employees at Hanford? My goodness, don't we want to encourage employees at Hanford to expose safety violations? I mean, I suggest we do. I suggest that it's imperative that we enforce that public policy. And there are a plethora of federal public policies that we need to enforce, so long as the public policy is enforceable in the state of Washington. It should be a basis or a source for the public policy tort. And there is where you quite simply draw the line. If Oregon or if Vermont has a public policy concerning gay marriages, and they do, I don't think we could seek to enforce that public policy in the state of Washington. I don't think we can think that all employers should be able to know the public policy of all 50 states, I think that would be unworkable. So I do think there are some parameters for the application of the tort. And I think so long as it's enforceable in the state of Washington, that should be the touchstone.
Well, counsel, it's not enforceable in this case in the state of Washington, is it? The ADA?
The ADA is, the public policy is enforceable in the state
Okay,
of Washington.
so you're making a distinction between the letter of the law and the public policy.
Roberts versus Dudley, Your
Well,
Honor.
I understand why you're doing it, but I just want to make it clear that you are doing it. I mean, it's not really that the legislation is enforceable in the state of Washington, because here it would not be.
The actual law is not enforceable in the state of Washington, and either was the law against Washington, the law against discrimination, Roberts versus Dudley. So I don't see that is a distinction, but I don't see it as a meaningful distinction. And we are asking the court to take an additional step, which is to apply Roberts versus Dudley to the ADA. First, for Mr. Sedlicek, you have to apply it to disability discrimination. And from what I can gather, there's not really a good argument against that, because the public policy in favor of disability discrimination is as strong as it is for gender discrimination. So I don't see an argument there.
It's not even really here, is it? I mean, the other side didn't preserve
I think that's right. I think that's right. So the only question is whether or not you can apply that same reasoning to the law against discrimination. The American with Disabilities Act. And we do believe that that is a clear mandate of public policy. We do believe that that public policy has not been manufactured by the Court of Appeals. It's a congressional mandate of public policy. And for that reason, we believe very strongly that this court should affirm the Court of Appeals. We believe most strongly that this court cannot reject federal law as a source of public policy. The consequences of that decision, I respectfully suggest, would be catastrophic.
Even if the federal law and state law, the policies underlying them are at odds?
They're not. If they truly were at odds, I think that would be a good argument. But in this case, I do not believe that they are inconsistent. This is not a question where they are in conflict. This is not a preemption scenario. They're not in conflict. They're not inconsistent. They do differ, but they can easily be harmonized. There's nothing inconsistent with our law against discrimination by applying it to associational discrimination and the right.
Do you agree that the federal law goes beyond the protections provided by state law, at least?
No,
you don't?
I don't.
Okay.
I think when the right case comes up, this court will be called upon to give it a liberal construction to state law, and we'll be asking this court to interpret our Washington state statute to provide for the very same protection, the associational prong. Now, that case hasn't come, and this court need not go that far in this case because it's not directly at issue. But so I don't believe, not only don't I believe that they're at odds, I believe that eventually this court will adopt the federal interpretation and will in fact find that the law against discrimination in Washington does provide for this associational protection to prevent disabled people from becoming pariahs. There is nothing inconsistent with that public policy with the law against discrimination in the state of Washington. They are entirely consistent.
Isn't that a job for the legislature to do what you just said?
What is that, Your Honor? To amend the statute?
Essentially, yeah.
Well, they could amend the statute, and the court, when that case comes before the court, Your Honor may well decide that we are not going to go so far as to interpret the law of the state of Washington, the law against discrimination, to provide for that protection, in which case employees will have to continue to rely on the public policy enunciated in the ADA. I ask this court, I thank this court for its attention and its time, and I ask this court to...
Well, if that case did come to us and we said, you know, we just don't think we can go that far, to extend the public policy would be up to the legislature, would then we say that the public policy underlying the federal and state statutes are contradictory or at odds?
I don't think they are contradictory. Your Honor, I'll say it again. The public policy underlining or underscoring the ADA and its associational protection is to prevent disabled people from becoming pariahs, which has been a historical problem for disabled people in this country. How can this court say that public policy is inconsistent with the law of the state of Washington? It's not inconsistent. It may differ. The federal law may be broader in its reach in this instance, but I can't see how they're in conflict, and I can't see how they're inconsistent. Thank you for your attention.
Thank you, Mr. Needle. Mr. Hickman, 12 minutes.
Thank you, Your Honor. I've heard some things in the last few minutes that caused me to pull out the Gardner case. 128 Washington 2nd, and I'm looking at page 936. There are two things here that I want to leave with the court. First of all, are things that I've already referenced. The four different situations which created this public policy tort, where employees are fired for refusing to commit an illegal act, where employees are fired for performing a public duty, where employees are fired for exercising a legal right, where employees are fired in retaliation for reporting employer misconduct. Those don't apply here. But counsel has just stood up there and said, if you don't rule in his favor, that all these things can happen. This is the law already. The guy over at Hanford is protected under this. The guy who doesn't want to turn in a phony income tax is protected under this. It is protection for an employee and what they do and how they do their job, that they don't violate law. That isn't this case. I've also heard Thompson talked about a bit. And here's what Gardner described. I was going to read it out of my brief, but I'll read it out of Gardner. Thompson involved a situation where a divisional comptroller had instituted an accounting program required by the Foreign Corrupt Practices Act, a federal law. The employee claimed he was terminated in retaliation for complying with the law. This court ruled a plaintiff could satisfy the elements of wrongful discharge claim by showing the discharge may have contravened a clearly stated public policy. That public policy wasn't just a federal statute. It was a federal criminal statute. That is what Thompson was about.
Well, counsel, you're not disagreeing, are you, that if the Hanford regulations didn't involve the violation of a crime, were being consistently violated, or there was a requirement that they be violated and someone was terminated for refusing, that would not satisfy Gardner, just because it was federal regulation?
This is exactly where the common law tort came from, for doing things that are so obvious.
Okay,
against
but
public policy.
Obviously against federal
and
law.
And it is an employee doing something. If these employees had refused or had engaged in age discrimination in the apartment house, if they had been fired for engaging in age discrimination, or if they'd been fired for not engaging in age discrimination, that's what we're talking about here.
I'm looking at the federal prong. You've argued we shouldn't look to federal law.
The last time I looked, this is a federal system. Each state is an independent entity. For counsel to stand up and say you cannot ignore the public policy declared by the U.S. Congress, I can't. Where's the constitutional hook, for one thing? Where's the Commerce Clause that applies the federal public policy to an apartment house that has 2 employees? It doesn't apply. This is a federal system, 50 individual states. The fact that Congress may have declared something is interesting, but it is in no way binding unless it is part of the supreme law of the land by going through the federal Constitution, and they've said up here they don't have an ADA claim. They couldn't even get into federal court.
Well, Mr. Hickman, you're not arguing that in order to violate public policy stated in a federal statute, it must be a crime, are you?
It would help. It certainly is a lot easier if it is a crime, but if it violates a statute, if they are fired for refusing to violate a statute, the Sedlicek are not fired for refusing to violate a statute.
Counsel,
this is a distinction that seems to have been lost. Excuse me, sir.
What if the state legislature passed a statute saying it's contrary to the public policy of the state of Washington to fire somebody because of their disability or fire someone because of their association with someone with a disability? How about that? Does that create a common law cause of action, do you think, or not?
It would read the entire statute.
That's
To whom
it.
that's all it says.
Right.
Would seem to certainly give the council a great deal to base a claim upon. But if they haven't provided anything other than that, it just exists in the air. I don't know if there would be a cause of action arising out of that. A simple declaration of public policy. They carried it on to, that's step 1, 2, 3, and 4.
Is there some case that says a simple declaration of public policy isn't sufficient to establish a
There are a great many cases that say when the legislature has put down its pen and stopped writing, we don't pick it up. This court has said that over and over again. When the legislature has stopped writing, we don't fill in the blanks. And that's what you're asking
You
here.
don't fill in the blanks by providing a remedy?
Sometimes you do and sometimes you don't. I don't know what the consistency is, but I do know that the court says that if the legislature doesn't provide it, we should be very reluctant, perhaps proceed very cautiously, perhaps view it very narrowly as the type of things that we're looking at here today.
Well, counsel, everywhere I turned in my questioning of your opponents came back to Roberts versus Dudley, and I think probably rightly so. Well, how do we overcome, to support your position, how do we overcome the broad strokes that Roberts versus Dudley was written with? It says, first off, we don't care that the statute doesn't apply to employers with fewer than 8 employees. It's nevertheless the public policy of the state of Washington. Why is it inappropriate to say the same thing about the ADA?
There's a the first significant difference is the fact that the state has adopted, and I guess it is very difficult to distinguish. My fundamental distinction, as far as Roberts is concerned, is the existence of the Equal Rights Amendment. To me, that makes a world of difference in the analysis, because the state constitution is the supreme law of the state of Washington. And under the Equal Rights Amendment, I think that case can be justified. But it can't go any further, because the Equal Rights Amendment doesn't extend to disability or age or the rest of it.
Counsel, do you think the Equal Rights Amendment creates a remedy for its violation?
It doesn't create a remedy so much as it limits and restricts, I believe, discrimination, and allows or disallows it. Says, well, prohibits it is what it does. Counsel, in their brief, page 15, 16, perhaps an answer to anticipating the court's question of where is the public policy, and as counsel said, to find a public policy, lists 18 different places to find public policy. I found it interesting. Almost any official, any bureaucrat, any judge, the catch-all in there, an authoritative public declaration. If Governor Locke holds a press conference and declares the public policy of the state of Washington, or if the Speaker of the House declares public policy of the state of Washington, or if one of the justices here were to step outside and declare the public policy of the state of Washington, according to counsel, those are some of the rocks that we can look under. But that's nonsense. We're dealing with a common law tort, and has been developed. And the first thing that was developed is to say it was narrow. The second thing we look at is where did it come from? And it came from employees being discharged for refusing to violate a law, employees being discharged for exercising their right under law. And that's not this case.
Well, Counsel Gardner is certainly an exercise in trying to find something that arguably isn't there. But nevertheless, the court was able to find some clear law that the employee was fired for refusing to violate it. Is that your reading of Gardner?
I'm going to close up here and answer your question at the same time. In preparing to come down here, I came across an article in a publication that many of you are very familiar with or were familiar with in law school. It's the Washington Law Review. And this is an article which appeared in the January 2001 issue. And I would very much hope the court would think about what's said here when you are deciding this case. This is from the conclusion.
Who wrote the article?
It was written by a gentleman named Brian Hersey. This is in the notes and comments section. Given the Thompson's Court statement of a clear mandate and the plain language of the small employer exemption, the Roberts majority's justifications for determining that the Washington law against discrimination is a sufficiently clear mandate of public policy to support a tort of wrongful discharge are not convincing. Although Washington law against discrimination may indicate a general policy against employment discrimination, the exemption for small employers held constitutionally sound should have precluded the court from finding a clear mandate of public policy. Instead, the Roberts opinion gives courts free rein to create remedies and public policies where they see fit by dissecting statutes without the support of legislative history. The Roberts opinion chose to set a precedent that broadening the holding of Thompson to give Washington courts the ability to construct public policy too broadly and thereby threaten the balance of powers on which the government is founded. And that folds over into our case.
Did he make any reference to our, at least four of us, as you've already pointed out,
Yes.
laid emphasis on the Equal Rights Amendment?
Yes. Yes, that is.
He does.
Yes, it
mention that.
does. Yes. That is what it comes down to. It was alluded to in the earlier argument. The balance of powers within our government, three-part system, and the fact that this body is the judicial body, that body is the legislative body. Please keep that in mind. Thank you.
Thank you, Mr. Hickman. The court will be in recess until 1:30 this afternoon.
The Supreme Court is in recess.
You're watching TVW, Washington's public affairs television network.